The matter before the court is MMG Insurance Company versus the estate of Philip Greenlaw et al. The matter is Cumberland 23228. And it appears counsel are present. I would ask counsel to identify yourselves at the podium and the party that you represent. We are being recorded and streamed live on the web. For the appellant, please.
Peterson for the appellant, the estate of Philip J. Greenlaw. Thank you.
Carol Eisenberg for appellee MMG Insurance Company.
Yeah. And counsel, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. May it please the court. You look at this cold summary judgment record, it tells a very tragic story. Philip J. Greenlaw died on May 20th, 2019, at the age of 41 years old, while playfully wrestling with one of his best friends. That snapshot in time is not the whole story, it's not the only story, and it's not the reason why we are here today, Your Honors. We are here because Mr. Greenlaw's best friend, who accidentally and tragically killed Mr. Greenlaw, was an MMG Insurance Company's insured under a business policy. Their insured did not go to Mr. Greenlaw's home with the intent to wrestle that night. Their insured went to Mr. Greenlaw's home that night because Mr. Greenlaw had been soliciting him about a proposed hydroseeding project for his business Cutter's Edge. And in the insured's busiest time of year for this hydroseeding business, he went to Mr. Greenlaw's home and he found a window of opportunity to perform an estimate for this job, which happened to be during a quote-unquote Monday night bike night that the two and other individuals were involved with. The insured did not show up to Mr. Greenlaw's house that night with a motorcycle cut on. He showed up that night with his work clothes on and his work truck and with his work tools and equipment. He did this to perform an estimate for Mr. Greenlaw. After the insured put his business equipment away, his work truck, two friends and two prospective business parties to a business deal imbibed throughout the evening, all while continuing to discuss their businesses and also this specific job with Mr. Greenlaw's wife, Jodi. This court should not sanction the trial court's analysis that puts blinders up to all those facts related to the business and only focuses on what happened in that moment where Mr. Greenlaw died. And with that, I'd be happy to take any questions, Your Honors.
In Travelers Indemnity Company versus Bryant from 2012, we said in a case where a person assaulted somebody, essentially a road rage incident, while driving a work truck, that the assault of the other person was not in respect to the conduct of the business, and therefore he was not insured. Whether or not he was working, that the actions in assaulting the other person were not taken with respect to the conduct of the business. Why isn't that controlling here?
Your Honor, unfortunately, I do not have that case in front of me. What I would say is that I think the record before this court on this summary judgment record shows that there is an issue about whether or not Mr. Greenlaw was working in the respect of his business, which he went there for the purpose of doing.
But I think the point of, if I take, looking at this, the Bryant case, I mean, you would agree that the wrestling itself was not in the conduct of the business.
I would agree that the act of putting someone in a chokehold for a hydroseeding business is correct.
And a little bit more broadly, wrestling with him was not in the conduct of the business in any way, was it?
That's fair, Your Honor. If this court were to hold that the only point in time that matters for purposes of this analysis is what happened exactly at the point that Mr. Greenlaw died, then we don't win on appeal, because that's exactly the finding that that Justice O'Neill made with the trial court. And in that case, Your Honor, I guess I would note too, and this is me having not really a recollection of that specific case, but this wasn't necessarily, this was an assault in that it was reckless, but this was an
understand that.
accident that occurred
And that's
between
why I
two
didn't want to
friends.
focus on the chokehold. I understand that there's no thought that it was intentional.
Yes, Your Honor.
But counsel, that may not be the only point in time that's dispositive here. I mean, there are a number of other undisputed facts which the court relied on in issuing its judgment, including that by the time Ms. Greenlaw came home at 8 o'clock, the party had started. And everyone was inebriated, I think is what the record shows. That was at 8 o'clock. And then this incident occurred, 2 hours later during the course of this social event that these gentlemen engaged in every Monday night? I mean, what is there for a jury to figure out here that isn't already pretty clear from the undisputed facts?
Your Honor, I agree with your recitation of the timeline here. I would note that the insured arrives at Mr. Greenlaw after he was one of the last ones to be at this meeting. That's in the record as an undisputed statement of material fact. I'd also note that with regard to the consumption of alcohol, these meetings were not just about drinking beer and talking about motorcycles and going on motorcycle rides. In the summary judgment record, it's clear that these were strong businessmen, I believe is the actual language, that engaged in business deals with one another, such that one individual, McNeely, stated that there was only one person that he had not done business with. These were networking events in a way. May not be the same networking events that I attend, or that other people in different business industries may attend, but it still was.
But isn't that really incidental? I mean, I may get together with other judges and, have dinner or whatever, and it's social, even if we might actually talk about a case or what happened at work. That doesn't take it out of being a social event.
Yes, Your Honor, but that's the exact issue that I think is better left for a trier of fact, is to decide, was this incidental after hearing all the evidence, or is this something that's more blended and it's a mixed, and I think some of the cases talk about incidental versus the primary purpose. I would also note the primary purpose of him going there that night was to take an estimate for a hydroseeding business. But ultimately, in our view, this is a trial issue, or the trier of fact's going to have to make decisions, credibility determinations, and decide whether or not this whole night, whether whether the insured was there with respect to the conduct of the business.
On a sort of separate point, under the exclusions, I mean, wrestling, two adult men wrestling, whether it be playful, I don't know how you probably playfully wrestle, but wrestling with each other, it is not unreasonable to assume that somebody could get hurt as a result of that. It's expected. And one of the exclusions says this insurance does not apply to bodily injury expected or intended from the standpoint of the insured. If we assume that two adult men voluntarily, or maybe even involuntarily, engage in wrestling, because injury is certainly to be expected from that, doesn't that exclusion right there take it right out of the policy?
Well, there was never claimed at the trial court below. There was never that this case is an issue of an exclusion. And so the issue before the trial court below was whether or not what happened that night was with respect to the conduct of the business.
Conduct of the business, yeah.
Yes, Your Honor.
Okay, so nobody ever addressed that exclusion?
No, Your Honor, not from my understanding of the record. This was never raised.
Okay.
Well, you talk about the events that evening. This was your, Mr. McNeely's busy season, but he still made his way there, as you say, to, I gather, measure the yard for purposes of some work that Mr. Greenlaw wanted done. But as a part of this record, isn't it true that once Mr. McNeely had finished doing the measurements, he considered himself to be, I think the quote was, off duty. He wasn't working. And is that accurate?
That's what he testified to in a deposition, yes, Your Honor. I guess I would push back a little bit on, he made time to go there. This was his busy season, as Your Honor indicated, so this wasn't a situation where, I'm going to go to Monday Night Bike Night, and while I'm there, I'm just going to do this estimate.
Oh, no, it was, as I believe the record shows, it was a window of opportunity, given the fact that it was poor weather that night. One of the other purposes of these gatherings, as I understand it, is that the commonality was that everybody had an interest in riding motorcycles. But that didn't happen that night, and he thought he could do the measurement but still attend the gathering, correct?
Correct, Your Honor.
So characterizing this as a networking event, there was some work that was discussed at the event, but primarily they were gathering for social purposes. Isn't that true?
No, well, primarily, the insured went there in order to do an estimate and then hung around afterwards to attend Monday Night Bike Night, where they had continued discussing their businesses, which is in the record. And then he later that night, after individuals had started to leave the meeting, spoke with Mr. Greenlaw's wife in order to talk about the estimate.
But Justice Lawrence's question, I mean, there was no question that the purpose of Monday Night Bike Nights was primarily social. Whether or not people might discuss business, make contacts, it's a good thing to do business with people you know, all of that. That wasn't the primary purpose of those gatherings, was it?
Perhaps not, Your Honor, but that's not the focus. The focus should be.
I understand you're focusing on something else.
Yes, Your Honor. Well, I would just argue that the focus should be on the insured. What was his primary focus on going to Monday night? It wasn't to go to Monday Night Bike Night. It was to go take an estimate for someone who was a friend, but also somebody who he was trying to solicit business from.
Well, that's why he went, and he did that business, and then he sort of went off the clock, didn't he?
Well, he testified in the deposition that he considered himself off duty that night.
Yeah.
But he continued to discuss Cutter's Edge business, and he continued to talk about the specific project with Mr. Greenlaw's wife. So regardless of what he testifies in his deposition, this is something that a trier of fact needs to hear. And when somebody testifies and says, I considered myself off duty, that's where a trial attorney then cross-examines and suggests, well, I understand you considered yourself off duty, but isn't it true that you also engaged in business that was related to Cutter's Edge? You spoke with Mr. Greenlaw's wife about this hydroseeding project. So I think ultimately this falls back on, this is an issue for a trier of fact to determine whether or not this was conduct done with respect of the insured's business.
Doesn't the record show that after he'd done the measurements, he discussed the matter with Mr. Greenlaw, and Mr. Greenlaw suggested that he wasn't going to make a decision that night because he needed to speak with his wife. And if I understand the record, there was never any further discussion between Mr. McNeely and Mr. Greenlaw about the project.
That's correct, Your Honor, with the exception of when Ms. Greenlaw
I was just talking about Mr. Greenlaw.
Yes, Your Honor. Yeah, that's correct, Your Honor. There's nothing in the record that has to do with Mr. Greenlaw speaking about the hydroseeding project after the estimate was done, other than this incident where Mr. Greenlaw comes up and talks to Mr. Greenlaw and the insured in order to have a conversation about how the estimate went later.
Mr. Greenlaw initiated the wrestling event, such as it was, correct?
That's correct, Your Honor.
And there wasn't any discussion about, well, you know, I'm going to wrestle you to make sure you take this job or anything of that nature?
No, there wasn't, Your Honor. Thank you.
Ms. Eisenberg? Be happy to hear from you.
Thank you. May it please the court. The policy provision at issue makes McNeely an insured only for actions that are with respect to the conduct of his lawn care business. It is uniformly agreed that this is an unambiguous clause that can be interpreted as a matter of law. There is no dispute about any material fact. MMG has admitted every aspect of McNeely's business-related conduct on the evening of May 20th, 2019 at Bike Night. And Greenlaw does not assert that McNeely's drunken wrestling was itself explicitly business conduct. In fact, you just heard that from counsel. The single issue for this court to decide is a legal question. Was McNeely acting with respect to the conduct of his lawn care business when Greenlaw died during their drunken wrestling match? You should affirm the summary judgment below, regardless of the prior business conduct that night. The drunken shenanigans among a group of close friends at what was essentially an after-party, while perhaps business adjacent, cannot reasonably be construed as being with respect to the conduct of business. Greenlaw misplaces reliance on inapposite cases that do not negate the analogous cases we have cited. The case that they rely on nationwide involves a factual dispute about the nature of the conduct that was going on at the time of the injury. Was the person doing business-related or non-business-related conduct? The other cases relied upon, State Farm, Cope, and Guide One, are also distinguishable. All of them involve mixed factual/legal questions. I would call them legal. Some of the courts refer to them as factual, but they're all about conduct that had a dual purpose at the time of the incident, at the injury. Someone was driving to do both a business and a personal errand, for instance. None of the cases we cite, and this case, do not involve any such dual purpose. There's no allegation, and nor could there be one, that the wrestling served a dual purpose.
Counsel, I see that the green light is on, and I'm going to follow up just on that last sentence. I think I asked your opponent, Mr. Peterson, whether or not, about the fact that the wrestling itself could not have possibly been serving a business purpose. But is that the right analysis? I mean, is it really that narrow? You made a comment that it's not exclusively business conduct, but that's not the language of the policy. It doesn't say exclusively.
It says that you are an insured when you are doing something with respect to the conduct of your business. And we have seen many courts look at conduct and say, look, we're not looking at everything you did in an evening. There's the case that we cited where someone is coming out of a business dinner and on the way out gets in a fist fight. And that court commented, very rarely is a fist fight with respect to the conduct of a business. It does not matter what came before. What matters is what you're doing at the time of. Another one of the cases we cited was the one in which a person who is a welder sets up a temporary shop outside a racetrack. He is there for the sole purpose of conducting his business. He takes a break from business, goes outside, sets off a firework, injures someone, and he is found not to be.
And those are not main cases.
Those are not main cases, nope. But they are analogous and soundly reasoned cases, as is often the case in Maine. We do not have one exactly on point.
So your position would be, I assume, that even if Mr. McNeely and Mr. Greenlaw had been talking about the hydroseeding project 2 minutes before the wrestling began, that we should focus on the wrestling and not the business discussion?
The cases we have seen that I have read all suggest that that is the proper analysis, and I think it makes sense. Otherwise, any poker game, any tennis match, any night out among coworkers at which there's a social event in which business comes up, if there's a subsequent conduct that is not business related, then they're trying to cast a big umbrella over the whole time period before. We have to draw a line somewhere, and the conduct, in this case, it wasn't immediately subsequent. There was no contention that 10 minutes before they were talking business.
Is drawing the timeline an issue of fact?
The timeline is agreed upon. There are no dispute of fact.
I shouldn't say the timeline. I think what you're referring to is the fact if something happened like contemporaneously or far in the distance, at what point is there a tipping point where it's not part of the conduct of the business? Is that an issue of fact?
No. I think it is a legal question for this court to decide whether the conduct is with respect to the conduct of business.
When Travelers, we said an ordinary person would not think the policy's language would cover that circumstances there. An ordinary person, so is it for the court to say that anybody looking at this, any ordinary person would not consider, or is it something that should go to an ordinary person on a jury to make that decision?
No, I don't. I think it would be an abdication of your responsibility to make answer the legal question of what constitutes being in the conduct of business. The facts, if they were in dispute, would be for a jury to decide. Did they talk about it 10 minutes before or 2 hours before? If we had those disputes, but we don't. We've admitted every fact that they have proposed. So you have the factual record. It now is a legal question whether on that record what happened was with respect to the conduct of business. That is not for a jury to be interpreting a policy and applying those facts to those policy provisions. That is exactly your province and is a legal question.
So it is the act of wrestling itself, not what preceded it, in your mind, that makes this a question of law. In other words, if Mr. Greenlaw had been injured somehow by Mr. McNeely in the course of sitting around during the meeting, that would be a jury question.
No, I disagree. I still think it's a legal question whether the agreed facts constitute actions within the conduct of, with respect to the conduct of business. That is the legal question. The facts are what happened. That's agreed here. How what happened matches up to the policy is the legal question that's for you to decide. And even if you were to draw a wider net than the exact moment when the wrestling match began, I cannot fathom one that is wide enough to encompass what happened here. I mean, to the extent there was, it was primarily, as you have observed, social event. Yes, there was some talk of business, and yes, they conducted business for a few minutes early in the evening, but it was primarily a social event. To the extent it was a partially business event, it had ended. It was over.
If they had started wrestling after while the two of them were out back looking at the lawn, measuring for the hydro seeding, talking about it, and then started goofing around and wrestling, and it happened there, would that be at least a fact question or a jury question?
I don't think that would be a jury question either. I mean, again, it would be an agreed fact about what happened, and that case would be very closely analogous to the one with the welder with the portable shop. You could have been working 2 minutes before. If the thing you are doing is not with respect to the conduct of your business, then you are not an insured when you are doing it.
We're all talking about wrestling as if it had nothing at all to do with the conduct of a landscaping business. Right.
I'm not sure I understand your question.
Well, your position assumes that wrestling has nothing to do with the conduct of a landscaping business, right?
I think that's a fair statement.
Is that a question of fact?
No. No, the facts are what happened.
But
What happened is agreed.
is what activity is involved in a landscaping business a question of fact?
I suppose it could, in some instances, be a question of fact whether certain conduct is with respect to the conduct of business.
You're
But
saying,
in
and
this-
I'm not necessarily disagreeing, you're saying wrestling is so far removed from any activity that could possibly be involved in a landscaping business that it is removed as a factual issue.
I say that, and I add to that Greenlaw has never raised any contention to the contrary. They have never said what was going on when they were wrestling was part and parcel of doing his landscaping business. They have said what happened earlier in the evening was part of doing the landscaping business, so the whole evening is part of the landscaping business. That's their argument. And as a matter of law, I'm saying, no, you have all the conduct before you that we agree on, and as a matter of law, things that are not conduct with respect to a business, there's no support in any case law to say that it should therefore make you an insured. The only cases they point to are not cases like this, where someone did something business-related earlier and a court found later conduct to be kind of scooped up with it. In all of those cases, the conduct at the time of injury, the ones that they point to, are cases where the conduct had a mixed business and personal purpose. You know, the pastor was coming home from the work/personal trip, picked up by an employee who was after hours. Was he working? Wasn't he working? They're always conduct that is a question about whether it was of dual purpose or whether it was a business purpose at all. In our case, there is no question and no argument from the other side that the conduct at the time of injury did not have anything to do with the conduct of his business.
Well, what if we take the hypothetical that the person, the potential client says to the person who's trying to sell his services, I will only entertain thinking about hiring you if we wrestle. And then you wrestle and he hurts himself. Is that covered?
Potentially, but it's not our situation.
Okay, so if he's not explicit about saying, I will only entertain this, but the insured thinks, I'd better wrestle with this guy when he asks because I want to be nice to this guy because otherwise I'm not going to get his business. If it's not that explicit, then does it become a jury question?
No, because the question, again, if it's agreed what happened, if there's a debate, if one person's saying he thought he had to do it and someone else is arguing that he didn't think he had to do it, if there's a factual dispute about the nature of what happened, sure, that's what a jury should resolve, what actually happened and what did people think about what happened. Again, that's just simply not the case we have here. There is no debate about what happened or why it happened. None of these questions have been raised about the wrestling itself by Greenlaw.
So if the evidence showed that the guy who's potentially hiring him likes to wrestle, and the insured said, well, I knew that he liked to wrestle, and that's why I wrestled. You're saying that's not a jury question because the facts are not in dispute, but would he be covered?
I hesitate to opine without all of the facts in this hypothetical, but I would say that it would still be the court's legal question about whether on those facts it was sufficient to be conduct with regard to the business. So it would depend on all of the facts.
Well, and what you're saying is in this case, we don't have any facts that he felt pressure to wrestle in order to get the business.
No suggestion at all of anything remotely resembling that.
And the summary judgment record here indicates that the decedent initiated this altercation.
It does, and it indicates that it was his habit and something that these close friends engaged in with some frequency as part of how they hung out and horsed around together.
There don't appear to be additional questions.
If I may, since I have a moment left, you did ask about whether it was intentional conduct, and in our brief on page 8, we do address the fact that there is that exclusion in the policy. The agreement below by Greenlaw and McNeely was to enter a judgment that it was not intentional. I mean, that is the judgment for which they are seeking to reach and apply.
Actually, my question was on expected result, which is a different exclusion, but as you say, you haven't litigated that exclusion.
Expected or intended.
It says it's the same exclusion, and
Expected
but
or intended.
that could be a factual question, but on the actual situation we have, there's none. And it is also the case in the record that both the homeowners policy and the business policy defended with reservations of rights, but the homeowners policy settled out. The Greenlaws have collected for their injuries.
Okay.
This is an effort to collect even more from a policy that I don't
So I
think is
understand this is a focused issue, a
Correct.
focused coverage issue. Okay.
Thank you.
Your Honors, if insurance companies wanted to make it so that incidents or occurrences had to be only about business-related issues, then they can write in their policies that very exact language.
And clearly, it doesn't say it has to be exclusively business conduct, but we had some questions and some hypotheticals. I mean, there's no suggestion here, is there, that the wrestling itself, and I understand you don't think that's the focus, but there's no suggestion that the wrestling itself in any way was furthering the business or done with respect to the conduct of the business, is there?
No, Your Honor, there's nothing in the summary judgment record that speaks to that narrow issue. But as you indicated, my argument is that we shouldn't just look to that. We should look like the cases in COPE into these other cases that think about the broader context and the nature of why people are going on trips, for example, like the case where they go to the pastors go to Bulgaria. If there's primarily an invite from a friend who's a pastor out in Bulgaria. They go there for a conference. They speak 3 days out of the 12-day conference, and they come home and they get in a car accident and pass away. And that's determined to be something that is a triable issue that a trier of fact needs to decide, not a court on summary judgment. And I think the court should adopt that same reasoning in this case.
Well, if Mr. McNeely had been hosting a group of people at his house, a group of clients, that would certainly make it look more like a business event. But as I understand it, this was at the Greenlaw house.
It was the Greenlaw house,
And
yes,
it
Your Honor.
wasn't a group of Mr. McNeely's clients or necessarily, at least it wasn't limited to that.
Well, Your Honor, all of these individuals did business together, and they rotated the place in which they did these Monday night bike nights. So when you think about that broader context that a trier of fact should hear about, is they're going to hear about how these men went to different houses and they spoke about business and they referred each other clients in business and spoke about their respective businesses. So all of that should be considered when making a decision on whether or not what happened on that day was done with respect to the conduct of the business, not just that brief incident that happened that caused Mr. Greenlaw's life.
Although in the context of this record, there's no indication that Mr. McNeely engaged in any wrestling with any of the other participants or attendees of that biker meeting that evening, correct?
Not that evening, no, Your Honor, but the summary judgment record does talk about how at least Mr. Greenlaw and the insured would engage in wrestling
Right,
on
I was talking about
prior
everybody else,
encounters.
but poor question, everyone other than Mr. Greenlaw.
Yes, that's fair, Your Honor.
Okay.
Thank you.
Thank you.